everybody, my name is Nasli Williams. I am a divorce attorney in Tableview, Cape Town. I am making these videos to answer all your family law questions. If you're getting divorced, if you want to apply for a parenting plan, if you want to apply for interim maintenance while you're getting divorced, these are the kind of questions that I would like to answer in these videos. Welcome to Amicus Lex. I am so happy to be here. I am so happy to answer your questions, and I'm so happy that Probono.Org asked me to do this. I am a director at Patton Williams Attorneys in Tableview. I am also the owner of IE Divorce, which is an online platform where you can apply directly online for your uncontested divorce. We draft all your parenting plans and your settlement agreements, and we make sure that you have a stress-free divorce and so that you can focus on yourself. I am also a panel attorney with Probono.Org. I am very, very, very proud to be a panel attorney. Probono.Org is a dynamic NGO that works together with a private legal fraternity or the private attorneys to make legal services accessible to the public for those who can't afford legal services. Like I said, I am so happy to be here. I'm very excited. Let's get into the video. So we got a question from our Facebook page. I have a follower that wants to know, she's amidst divorce proceedings and her husband has stopped paying all the household expenses. He's no longer paying the bond, he's no longer paying for a car, he's no longer paying for the children, he stopped paying the municipal accounts. So she's afraid that the divorce will last for a undetermined amount of time, and who's going to pay these expenses in the meantime? She's been a stay-at-home mom for all these years, so it's understandable that she's very worried about it. So what she needs to do in this case is she needs to apply for a Rule 43 order. This is if a divorce is in the High Court. If a divorce is in the regional court, she needs to apply for a Rule 58 order. So what is a Rule 43 order? A Rule 43 order is a very quick and speedy application procedure that you need to follow to get interim maintenance from your spouse. So while your divorce is pending, you will be receiving this maintenance or this interim maintenance while your divorce is pending from your spouse. So what can you use this Rule 43 order for? You can apply, like I just said, for interim maintenance. You can also apply for primary care or for contact with your minor children. You can also apply for a contribution to your legal costs and for your husband or your wife to keep on paying all the household expenses that he or she has been paying while you guys were together in the matrimonial home. So the Rule 43 is a very, very strict rule. You basically only get one opportunity to file your affidavit. So the purpose is that you get speedy relief and cheap relief. If the court is going to allow you to file affidavit on affidavit on affidavit, it's going to lengthen the process. Speedy is going to fly out of the window, and it's not going to be inexpensive anymore. So the rule is strict. You need to make sure that that first affidavit that you submit to the court or your Rule 43 statement, you have to make sure that it is concise. Court doesn't want a lot of papers. You have to make sure that the papers are complete and that is accurate. And then I would prefer that people who want to apply for a Rule 43 order get legal advice, because you cannot appeal a Rule 43 order. You cannot later go back and say, listen, I didn't place this information before the court, or I didn't complete this, or I forgot to mention something, I want to appeal this. You can't do that. The only way that you can amend a Rule 43 order is if there is a material change in your circumstances. So you filing incorrect documents in the process, or you giving the court incomplete information, wouldn't be seen as a material reason for the court to amend the papers. So what would be a material change? A material change would, for instance, be where you got dismissed from your employment, you got demoted, you can no longer afford to pay the amount, or your child needs a very expensive surgery, medical expenses all of a sudden. Those are the kind of things that the court would consider as material circumstances that would justify the amendment or the variation of your Rule 43 order. Obviously, every case will be different, and each case will be decided on its merits. So there's a lot of factors that that the court could keep in mind or take into consideration for your case that they won't take into consideration for another case. So it will be a case-by-case decision or evaluation by the court. I hope that answers your question. Thank you. I've got another question from one of my Facebook page followers. This is a question that I get quite often on my page. She wants to know whether she can divorce her husband without having him served, meaning she wants to get divorced without notifying her husband. Unfortunately, you cannot do that. You need to serve your spouse with the divorce papers. According to the court rules, a divorce summons must be personally served on the defendant. So your spouse will have 10 days in which to notice defense or to file his notice of intention to defend and serve you with it. You will then have 20 days to submit his plea to the court or to make a counterclaim against you. So basically both parties needs to be heard, and I mean this is a matter of status, you know. People, it's very important that your spouse does get served so that he or she has an opportunity to defend themselves against your claims. So I hope that answers your question. I'm not really sure what else to say on that. If you can't find your spouse, that's another question that people ask me. What if I can't find him? If you can't find your spouse, then you need to apply to the court to have him served by or her served by an alternative method, by, for instance, posting the summons to an address, last known address, or posting on his Facebook page, or WhatsApping the summons to him. But that is a special procedure of a special application that you need to make. So you have to ask the court for special leave to do that, and you need to prove to the court that you can't find your spouse, that you've made reasonable attempts, maybe even more than reasonable attempts, to try and locate your spouse to serve him with a divorce summons. I hope that answers your question. If it didn't, then let me know. Then I can just maybe get you a more structured answer to this question. Thank you. So that is it for today. I really enjoy making these videos. Please, if you have any questions, you can leave it on one of my Facebook pages at @iedivorce/, or you can leave it on my firm's page, which is at Patton Williams Inc. /. And then just a tiny little bit of a disclaimer. These videos are for informational purposes, for guidance only. It does not constitute legal advice. If you do have a legal matter, please seek legal help or assistance from your own attorney. This is purely for information. In fact, many attorneys disagree on many kind of legal issues or legal problems. So, you know, get a second opinion. I am trying to help from my side, and I really enjoy making these videos for Probono.Org. Speaking of Probono.Org, if you are a legal practitioner, please sign up to be a panel attorney of Probono.Org. They can really do with all the help and all the assistance. There are so many people out there who does not have access to legal services, who cannot afford legal services. So really it will help them so much. So that is it. Thank you so much for watching this video. I am looking forward to make the next one. So do not forget to leave me all those questions. Thank you so much. See you in the next video.